Case number 26-326 SM. We're here for an arraignment. Mr. Van Horn, did you read and sign this advice of rights form?
Yes.
The contact information on the back, was that accurate? Did you have the opportunity to meet with somebody from the defender's office today?
Yes, I spoke briefly with him.
All right. I have a complaint that alleges that on or about January 30th, 2026 in Springville Township of Wexford County, it is alleged that you committed the offense of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and potential penalties?
Yeah, sure.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I would like to have an appointment.
All right, court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Bond is based on the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I show that a $500 bond was posted over the weekend. Defendant's history includes in 17 a possession of a firearm under the influence, 18 driving a license suspended, 19 retail fraud third, 20 failed to provide a license, 22 jostling, 23 operating while intoxicated, failed to report an accident, and driving the license suspended. And the praxis was not complete because I could not get a hold of him. Sir, do you have a good telephone number?
Yeah, it is 231.
All right. And how long have you, is Iris Street a good mailing address for you?
Yes, it is.
Do you actually reside there?
Yeah, I do now.
How long have you lived there?
Just this last month.
All right, and are you currently employed?
I've been working just self-employed on and off. I do roofing, but it's not been very best weather for it right now.
Based on those responses, I believe that puts the praxis at a risk level 2. Any comment regarding bond, Mr. Harrison?
I would simply have the court continue the $500 bond that's already been posted. He does have criminal history, as the court noted. I would, just for the record, state those are all misdemeanor offenses on the report that I have. He's not a flight risk. He is from this area, lived here his whole life, despite the fact that he's only been at that residence for a month. Thank you.
Thank you. Ms. Dole?
I apologize. I just received this file a little bit late, but from my reading complaint, he punched the victim in the back of the head, and the officer was able to feel a large bump in the back of her head, approximately the size of a golf ball. When she tried to leave, he hid her medication from her. And pushed her to the ground and was holding her down with his body weight. And at that point, he hit her in the right eye.
To what is this hearsay?
It's relevant
To the-
The conduct.
Mr. Harrison, we do this every day. You know the process we go through.
Your Honor, this is, he does have a past criminal history. I'm sorry, he does have a past with assault crimes. And he has past that would cause us to believe that he is a danger to the community and specifically to the victim. We'd ask for no contact in this case and some bond now and testing.
Is there allegations of drug or alcohol use?
There was your Honor, just a moment.
Sure.
I didn't have a chance to review it prior.
I understand.
Yes, there is information that the were both drinking that day. Defendant took a PBT at the time.
Did or did not?
He did not, yeah.
All right. All right, the defendant presents himself today, so I do not find him as a flight risk, so I will continue the bond as previously set. Mr. Van Horn, you are to appear as ordered. Keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm ordering that you not have any contact with the alleged victim in this case, Jessica Rogers. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. Do you understand that?
Yes, sir.
Because alcohol is alleged to have been involved here, I am going to order a no alcohol provision along with random testings. You are not to purchase or possess any firearms or weapons or act in any violent, threatening, or intimidating behavior. If you are found to be in violation of your bond conditions, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that? All right. You can go out to the front window where you checked in, get your next court date. You'll have some paperwork to fill out for the defender's office. And then you'll need to go downstairs to community corrections and get signed up for testing. All right.
Thank you.
Thank you. Person at the jail, please state your name. I'm sorry, I didn't hear you. You might be muted on your end, maybe.
Sherry Marie Merritt, Your Honor.
All right. This is case number 19-1117 FY, the people of the state of Michigan versus Sherry Marie Merritt. Mr. Harwell, you appear on behalf of Ms. Merritt, is that correct?
Yes, Your Honor. Cameron Harrell appearing on behalf of the defendant, who is appearing via Zoom teleconference. We have no objection to the form of the proceeding, Your Honor. That is correct. For edification of the record, I was previously heretofore today, I was retained on what I believe to be a misdemeanor. The case was 1117 SD. But it's been my understanding after speaking to the prosecution that has been amended. This complaint is somewhat dated, Your Honor. They were waiting on, I believe, lab results. For clarification of the record, Your Honor, we have no objection, and my client has no objection to Your Honor proceeding. We feel confident that the court will be fair and impartial, and we have no objection to the court continuing as the court as the judge in this matter. Is that correct, Ms. Merritt? We have no objection to Mr. Wiggins proceeding
Yes,
as the
sir.
judge. Thank you.
Correct, sir.
I've discussed the ramifications of the conflict of the waiver with my client. She understands same, she will waive that, Your Honor. But at this point, I believe it was set for a bond violation hearing, Your Honor. I believe it appropriate that we set this matter for a hearing so I can become fully apprised of the context of the violations, if you will. And also, I'd like to get a full copy of the police report as well as the updated lab reports. No further information at this time.
All right. I'll note Ms. Dull appears on behalf of the people. Ms. Merritt, I have signed that waiver of disqualification, so I will proceed as the judge in this case. So you're actually going to be here for two things today. The first is an alleged bond violation. The bench warrant, it's alleged that you violated bond by failing to appear for a random test as ordered on April 22nd of 2019. That you took a sober link test late on February 21st of 2019 and failed to appear for follow-up ETG on April 22nd of 19. You failed to take a sober link test on April 23rd of 19 and April 24th of 19. You do have the right to have a contested hearing in regards to that bond violation where the people would have to convince the court that you did in fact violate your bond conditions. And I understand Mr. Harwell is requesting that that portion be set for a contested hearing.
That is correct, Your Honor. Again, I don't believe we are going to contest the violations, but I did have a meeting with Ms. Merritt at the jail. It did give me some concern. It would cause her to possibly request a contested hearing relative to those issues. So yes, I would ask that be set by contested hearing.
All right, so we will set the bond violation for contested hearing, which brings us to the second reason that you're here, and that is there has been an amended complaint filed in this case. The original complaint filed back in 2019 Just a minute here. Charged you with operating while intoxicated as a second offender. The new complaint alleges that on or about April 19th of 2019 in Colfax Township of Wexford County, it's alleged in count number 1 that you committed the offense of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail. However, they have elected to charge you as the second offender. That is a misdemeanor punishable by $200 to $1,000 and 5 days to 1 year in jail, or 30 to 90 days of community service, or both, along with rehabilitative programs, reimbursements for the cost of prosecution and governmental expenses. In count number 2, and this is where the amendments come in count number 2, it's alleged that you committed the offense of possession of methamphetamine. That is a 10-year felony, meaning that you could be sentenced up to prison for 10 years and or a fine of $15,000. The people have also charged you as a second or subsequent offender, meaning that you have at least one prior drug conviction in your past. That brings that 10-year felony up to a 20-year felony and or a $30,000 fine. In the alternative, they have also charged you as a habitual offender, third offender, meaning that you have at least 2 prior either attempted or completed felonies in your past. That makes that 10-year felony punishable by up to 20 years and the $15,000 up to 30 years. Do you understand those charges and the potential penalties? I'm sorry,
Yes,
I
Your
said
Honor.
30 years, $30,000 I meant. I apologize. Do you understand that?
Yes, Your Honor.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to have an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. I know you have Mr. Harwell now, but if something happens and you decide that you want a public attorney, let us know and we'll make that referral. Do you understand that?
Yes, Your Honor.
Ms. Merritt, I have a mailing address for you on Marion Street. Is that still a good mailing address for you? Or I'm sorry,
No, Your
I've got an updated one on 13 Mile Road. Is that accurate?
Yes, Your Honor.
All right. Mr. Harwell, how does your client plead to the amended complaint?
Thank you. At this time, my client will stand mute to the charges as filed.
All right, the defendant having stand mute, the court will enter a not guilty plea and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. However, if they are able to do that, you would be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together and see if there's a way to resolve the case short of going to trial. Historically, counsel, I show a 99 in retail fraud, 3rd, 04 controlled substance, and manufacturing charge, 11 use, in 11 attempted harbor of a felon, and in 12 an operating while intoxicated. The praxis scores her at a risk level 3. Any comment regarding bond, Mr. Harwell?
Your Honor, I would ask the court to set a bond. I understand that the court would be concerned about her flight risk. But at this point, Your Honor, I would ask the court to consider imposing a reasonable bond. She does, as the court is aware, she does have a previous bond issue in the case that was pending. But I would ask the court to consider imposing a reasonable bond. She is currently without a lot of needs at this point and has very limited resources. I would ask the court to consider taking that into effect and imposing bond.
All right, it looks like she was brought over from Manistee.
That is correct.
Ms. Dahl, any comment regarding bond?
Your Honor, obviously, the people believe she is a flight risk, considering the amended charges. She's also a danger to the community. She states there's a statement on the praxis that says that she was clean 6 years, but she's made no attempt to deal with this case in any way. So I believe a monetary bond would be appropriate in this case. And also, well, I believe it's an OWI with drug lab results came back showing multiple substances in her system, which we will provide to the defense as soon as we can. But I would ask for drug testing to ensure that she is in fact clean from any substances.
Thank you. Ms. Merritt has been in absconder status since 2019. The court does find her as a flight risk and will remand the defendant to the custody of the Wexford County Jail without bond until we have the hearing, and then we can address bond at that time. Anything else for the record, counsel?
Nothing from the defense, Your Honor. Thank you.
All right, thank you. Next arraignment.
Thank you.
Thank you, Mr. Harlow. Court calls the people of the state of Michigan versus Teresa Jean Leatherman.